case briefs, and so much more. LSData's got what you're looking for.
In the fascinating legal battle of Bomberger versus McKelvey, heard by the Supreme Court of California in 1950, the underpinnings of contract law were put to the test, particularly the mitigation principle. This concept argues that the law expects non-breaching parties to, within reason, minimize the extent of damages suffered by taking necessary steps should a contract be breached. Delving into the heart of the matter, the defendant, D.P. McKelvey, had entered into an agreement to purchase a property from the plaintiffs, which housed an old structure. McKelvey aimed to demolish the building to establish a supermarket and parking lots. Interestingly, the plaintiffs sought to salvage the skylights and glass from the structure for further usage. Therefore, McKelvey consented to meet a demolition fee of $3,500 for the plaintiffs. However, the plot thickened when McKelvey delayed their building plans. Fearing they might lose their chance to retrieve the precious glass and skylights, plaintiffs preemptively carried out the demolition. In a turn of events, McKelvey reneged on the payment, leading to the lawsuit. The original judgment came from the lower court, which sided with the plaintiffs. The court ruled that the plaintiffs were justified in carrying out the demolition preemptively given the uncertain circumstances, and consequently awarded the damages in their favor. This case confirmed that even after a breach is noticed, the plaintiff can continue performing. This verdict opens an interesting discussion on contract law and the balance of commitments and rights. The court's ruling suggests their interest in contract performance extended beyond monetary gains, reinforcing the idea that damages might not be an adequate resolution in all situations.
Case briefs, and so much more. LSData's got what you're looking for. Visit LSD.law, elevate your mind. Leave the stress of class.